Welcome to Think Tech Talks here on a given Friday. I'm Jay Fidell. Today we're going to talk about life in the law. This is our Life in the Law series. And the title of our episode is the U.S. Supreme Court next week. So a very timely show. Okay, and our special guests are my brother, Jay Fidell, and my sister-in-law, Linda Greenhouse, both teaching at Yale Law School. Thank you for coming on the show, you guys.
Thank you for having us.
It's a pleasure to be here. Fun to have you here. We must have fun no matter what.
Okay.
Okay, so just to, do a little background here. They are here. You can elucidate or rebut as you wish. They are here because they are the Den and Maggie Inoue Distinguished Chairs in Residence at the law school this week, which is really something. And in the way of background also, Linda Greenhouse worked for the New York Times for 40 years. You got to get around that. 40 years.
Right.
And she covered the United States Supreme Court for most of that time. Sure. She was the principal reporter on the United States Supreme Court. She also wrote a couple of books here. One of them was Becoming Harry Blackman, and the other had to do with prior to Roe v. Wade. What was it?
And my latest book is a little paperback called The U.S. Supreme Court, A Very Short Introduction. So if somebody wants to have a very short introduction to the U.S. Supreme Court, I would say this is the book to buy.
Okay.
But you don't have to be very short to get it.
No, and that's
regardless of height.
That's why I can probably buy it without any sense of guilt or recrimination.
Right.
Huh? Okay, and Gene, after a time in the United States Coast Guard, practiced law in Washington, D.C. He changed firms in 1980 or so.
Something.
80 or so. Became a partner in a firm called Felsman Tucker, Lifer, Fidell, and Banks, as I recall. And started practicing military. Actually, he was always practicing military justice law. Now, I would say he's the prime authority in the country on military justice. He was the founder and chief executive officer, or whatever the title was, for the Institute of Military Justice for a long time. Still is associated with them, and he has a blog. What's the name of the blog, Gene?
The name of the blog is Global Military Justice Reform, and the address is globalmjreform.blogspot.com, and any viewer is welcome to take a look and post comments and tell us what you think.
He's also written a case book, wasn't it, on military justice?
Correct, with two friends, Professor Elizabeth Hillman from Hastings Law School in California and Dwight Sullivan. I have written a book called Military Justice, Cases and Materials, which is now in its second edition.
Okay. So, I want to say both my brother Gene and Linda Greenhouse are teaching at Yale Law School. Linda, what are your topics that you teach?
Well, my specialty is the U.S. Supreme Court, having covered it on a daily basis for the New York Times for 30 years.
That's a reasonable choice.
Right. So I teach in our Supreme Court clinic, in which students work on real Supreme Court cases, and I teach about the court in various courses, various contexts.
Gene?
Well, my key specialty is military justice, as you mentioned, Jay. But in addition to that, I teach courses on federal Indian law. I teach a class on American Indian tribal law, which is the internal law of the tribes. Next year, I'm going to try a new course, bigfooting a little bit in Linda's bailiwick. I'm going to teach a course on a particular part of the U.S. Supreme Court's jurisdiction where they, for example, deal with disputes between states. It's called the original jurisdiction of the Supreme Court. Very interesting cases, not widely studied, so it'll be fun and an opportunity to do some history.
This is just another reason why you should go to law school and apply to Yale. It's that simple.
If only.
Okay, well, anyway, getting down to what we're here for today, and that is a substantive discussion. The title is the U.S. Supreme Court next week, but we're going to go wider than that. But let's start with you, Linda. You have a couple of pieces in the Times in recent days. You write every 2 weeks for the Times, even though you're retired. And one of them had to do with the 35-foot buffer in McCullen versus Coakley. Can we talk about that?
Yeah. So the court heard a couple of weeks ago a challenge to a buffer zone that the state of Massachusetts requires around medical facilities that perform abortions, a 35-foot buffer zone. And the question is whether keeping those who wish to protest abortion, or as they would put it, counsel women against going forward with their scheduled terminations of their pregnancy, whether that violates the First Amendment, whether it creates a speech-free zone that violates the First Amendment. And the court has dealt with issues like this over the years because given, as viewers probably know, a history of extremely violent protests around abortion clinics, up to and including the murder of doctors who perform abortions, sometimes actually in the clinics. Various states have tried to protect clinic staff and patients by creating these buffer zones within which people have to stay out of them, and only the patients and their escorts can enter. So the lower court in this case, the Federal Appeals Court in Boston, upheld this buffer zone, rejected the First Amendment claims, saying that this was an appropriate time, place, and manner regulation of speech. It wasn't a ban of speech. You could stand 36 feet away and speak all you like. So the Supreme Court agreed to hear this appeal. They heard it, as I said, a few weeks ago, and they will decide it sometime between next week and the end of June.
Were you at the argument?
No, I was not at the argument. Since I teach full-time these days at Yale and New Haven, I don't get to too many arguments, but I do read the transcript. And actually any of your viewers who's interested in reading the transcript of any Supreme Court argument, the court puts the transcripts up on their website the same day. It's supremecourt.gov, Supreme Court, all one word, .gov. And anybody can read the transcript, and anybody can actually listen to the audio of the argument, which the court puts up every Friday. All the cases they've heard that week, the audio will go up on Friday on the website.
How did it go?
How the argument goes? So there were some justices who were very skeptical of this regulation. So Justice Scalia, for instance, said to the lawyer for the state, "Stop calling these people protesters. They just want to counsel and give gentle advice to the women." So, it was clear that this regulation comes with a pretty heavy load before the court. On the other hand, the court has, on at least 2 occasions, upheld various kinds of speech restrictions around abortion clinics. So the court itself would have a challenging job, assuming they don't want to just flat out overrule those earlier decisions, which they may. If there's 5 votes, they may. But assuming they don't want to go that far, they'll find some way to distinguish the current case from the earlier cases and say those precedents, even to the extent they're still good law, don't apply because they were worded somewhat differently. They had a different construct. So I think this particular regulation could well fall. Exactly how far the court will go or how broad the language of the opinion would be, we'll wait and see. But people might want to be aware that the First Amendment, which of course we're all trained to stand and salute, the First Amendment's a good thing.
Except when you're calling fire in the theater.
Right. The First Amendment in the hands of the current majority on the Supreme Court has become basically a tool of deregulation. It's become a very corporate-friendly amendment that's been invoked and used very creatively and very aggressively by the current Supreme Court majority to invalidate all kinds of regulations, from campaign finance regulations. People are certainly aware of the Citizens United case, which was a First Amendment ruling, even things like tobacco regulation, food and drug regulation. Companies have a right to advertise as they wish or speak as they wish, and so regulations that I'm sure 10 or 20 years ago just would have been upheld automatically are now falling under the court's First Amendment sword and are being invalidated. So it's a current trend on the court that bears, I think, a lot closer watching than it's usually getting.
So speaking of trends, and you've written other pieces we'll talk about, but speaking of trends, just to get a handle on it, Roe v. Wade, in the view of a lot of people, was a really enlightened decision. And for a long time, it stood as the beacon of, the right to have an abortion. But in recent years, that seems to have declined dramatically and is declining. Okay, what's the landscape right now? It seems to me that, Roe v. Wade is in increasing jeopardy these days.
Well, it's in increasing jeopardy because for the last 25 years or so, a series of Republican presidents have put people on the federal courts, not only the Supreme Court, but the lower courts, in the belief that those people would be judges who would, if not totally overturn Roe against Wade, would hollow it out, and that's happened to some degree. So there are cases working their way up in the pipeline that, for instance, all kinds of regulations. Some would flat out ban abortion at a certain point, and the court in Roe against Wade, and the court has reaffirmed this since, has said you cannot ban abortion before viability, before the fetus could have an independent life. But some states don't want to live by that, so they're sending up test cases. There are regulations that, in the name of informed consent, the pregnant woman has to be told that if she goes ahead with the abortion, she'll be at risk of mental illness or suicide, which is totally false. Actually, the opposite is true. Have to listen to the fetal heartbeat, have to watch a prenatal sonogram, and all kinds of stuff like this. The most disturbing set of regulations, however, are known as TRAP regulations. TRAP stands for Targeted Regulation of Abortion Providers. So these are laws that single out abortion from among all other medical procedures and endeavor to ghettoize it, target it. So for instance, in Texas and other states, the legislatures have passed these laws that say that doctors, that it's a crime for a doctor to perform an abortion unless that doctor has received admitting privileges at a local hospital. Well, the only reason for doing this, and of course most abortions take place very early in pregnancy and nobody needs to get near a hospital, and if there's any emergency, which there hardly ever is, but if there should be an emergency, of course hospitals are required by federal law to take care of any patients who are sent to the hospital, whether or not the doctor has admitting privileges. So the only reason for this law is to shut down abortion clinics, because in certain areas of the country, the hospitals are kind of little monopolies and are under the control of people who don't want abortions to be performed in the vicinity, so they refuse to give admitting privileges. So for instance, in Texas, all the abortion clinics in the Rio Grande Valley have been forced to shut down because of this. And I've been in the Rio Grande Valley. It's an extremely poor part of the country. It's one of the poorest parts of the country. The federal appeals court judge who wrote the opinion upholding this regulation said, well, this is not a ban on abortion, because all women have to do is get in their car and drive 150 miles to Corpus Christi, where they can get an abortion there. Now, that's like telling these women who don't have access to transportation, who may be undocumented immigrants who are afraid to drive very far from their communities. It's like telling them to, find a car somewhere and drive to the moon. So it's a very cynical piece of legislation. The decision upholding it is very cynical. It may reach the Supreme Court within the next few months, and we'll see what the court does.
Scary. So then there's this SB 1062 in Arizona, the one that was, vetoed because it was an outrage.
Okay, so switching gears a little bit. So
yeah, we'll come back to the Hobby Lobby in a little while.
Okay, so there was a law passed by the Arizona legislature that basically gives would have given businesses the right to refuse to do business with whoever they want. Now, of course, there are lots of federal civil rights regulations that would make such a law, ridiculous on its face. Under the public accommodation provisions of core federal civil rights laws, a business owner cannot discriminate on the basis of race, religion, gender, ethnicity, and so on. But the federal laws don't cover sexual orientation, and neither does Arizona law. So in enacting this statute, the idea was to empower business owners to raise as a defense, if they chose not to do business with gay men or lesbians, to say, oh, we're protected by this state of Arizona law that says that we don't have to. And this outrageous statute became a big flashpoint back on the mainland in the last month or so, and the national business community, and I think very significantly the National Football League, because the Super Bowl is supposed to be in Arizona next year, and there was a suggestion that the NFL might pull out of Arizona if this bill was signed into law by Governor Jan Brewer. So after much back and forth and, you know, pretending she was wringing her hands and giving deep thought to this, she vetoed it about 3 weeks ago. That does not end this controversy, because there are claims being raised in courts around the country by people who claim to be religious people that their religion prevents them, and there's a case pending now before the Supreme Court, prevents a photographer from agreeing to be hired to photograph a same-sex marriage ceremony. There's a claim by a baker who says I can't be required to bake a cake for a same-sex wedding. I'm not kidding. There's a claim by a florist who says I can't be required because of my religion to provide flowers for a same-sex wedding. I mean, this way lays total madness, and the country is going to have to figure out what kind of society we want to live in, or do we want to allow people under a shield of religious practice to target other people who simply want to engage them in the business which these businesses have a license to perform, and hold themselves out as public accommodations to members of the public, except for you and you. So this is not exactly a world that I think in the 21st century we want to be living in.
Yeah, I thought things would get better in the Obama administration, but it sort of carries forward from the Bush administration.
Yeah, I mean, it's not, I would kind of leave the Obama administration out of it. I would say what's happening is it's a kind of religion on the march, right? So, you know, we hear a lot of claims from the Catholic bishops and others that the Obama administration is declaring war on religion. No, actually, it's religion that's declaring war on civil society, by which I mean a society in which we all, despite our differences of background or opinion, have to manage to live together.
We'll take a short break, Linda. That's Linda Greenhouse, teaches at Yale, and she is my sister-in-law. And to her left, my brother, Jay Fidell. They're both here as Dan and Maggie Inouye distinguished chairs at the law school. We'll be right back after this break. Hello, I'm Jay Fidell of ThinkTech. On March 27th, at the YWCA downtown, Laniakea, we're having a luncheon program, a luncheon panel program we call the Midterm Legislative Report. We're going to present our 2014 Legislative Midterm Update, featuring Bob Toyofuku of Hawaii Advocates as our moderator, and a panel of leading state finance officials who will tell you about what's going on in the legislature about money this session. It's really important. Senator David Ige, chair of the Senate Ways and Means Committee, Representative Aaron Ling Johansson, co-vice chair of the House Finance Committee, Representative Sylvia Luke, chair of the House Finance Committee, Calbert Young, State Budget and Finance Director, all the people who are very important, who know about the state fiscal policy, the state finances this session. You know, they say we have a spare $884 million. How much do we really have? The Council of Revenues changed its mind about projections. And how are we going to spend that money or not? What effect will our, current $40 billion of unfunded liabilities have on all of this? And in an election year, what are the real priorities that are going to determine the money bills and the final result of the 2014 legislature as far as you are concerned? We'll cover current fiscal issues, bills of interest of the business community, and we'll look at the provisions, political dynamics, probabilities, price tags of crossover and passage this year. It'll be very interesting to find out what is going to happen here as far as your bills are concerned and as far as state initiatives are concerned. It's an essential program for anybody who wants to know the fiscal state of the state, or if you want to network with the legislators and like-minded attendees who are likewise interested in the subject. Sign up on thinktechhawaii.com. We look forward to seeing you there. Aloha. Okay, we're back. We're live. We're at Think Tech Talks. We're talking about life in the law and the U.S. Supreme Court next week, because things are happening there. And my brother Jay Fidell is on the left, and in the center, my sister-in-law, Linda Greenhouse, both teaching at Yale Law School and legal scholars. So we were talking about these various cases you've been writing about and thinking about, Linda, and the one we need to talk about is the one that's going to be argued on March 25th, on Tuesday. It's the Hobby Lobby case. Can you tell about that?
Right, so it's a case called Sebelius against Hobby Lobby. So people know about the Affordable Care Act, quote, Obamacare. I don't personally use that word. So the Department of Health and Human Services, enacting regulations under the Affordable Care Act, requires that employers who offer employee health insurance include as one of the benefits contraception coverage without a copay. So free contraception coverage for everybody covered by an employee health plan. That seems kind of obvious these days. In fact, many, if not most, employee health care plans already provide this coverage. So Hobby Lobby, I don't know if there's a Hobby Lobby here in Hawaii.
I don't think so.
It's a national chain of hobby stores. They've got 13,000 employees. It's a corporation. It's a privately held corporation owned by a family, a religious family, who opposes, they say they don't oppose contraception. In fact, they covered contraception before this regulation came in and became highly politicized, but now they don't want to cover certain of the long-lasting contraceptives that they say can prevent a fertilized egg from implanting in the uterine lining and consequently, in their view, cause an abortion. Actually, that's not the medical definition of abortion, because the medical definition says that there is no pregnancy until there's implantation, but setting that debate aside. So they claim a religious exemption from this requirement, and they claim it under a federal law called the Religious Freedom Restoration Act, which provides that any policy law imposed by the government that places a substantial burden, and that's a term of art, substantial burden, on the free exercise of religion, has to be justified by a compelling governmental interest, and it has to be as minimal as possible, as narrowly tailored as possible to serve that interest. So the government here says a couple of things. First, it says the law doesn't apply to corporations because corporations don't have a religion. A business organized in a corporate form doesn't pray, doesn't go to church, doesn't have a conscience, doesn't have religion, so the law doesn't apply. If the law applies, the government says, requiring business owners to cover contraception is not a substantial burden on the religious practice of the company or its owners, because it's not requiring anybody to use contraception, it's simply enabling the acquisition of free contraceptives. So business issues a paycheck to its employees, and obviously the employees can use their paychecks to buy contraception or to buy a gun or to buy whatever they want to buy, and that's just the way our economy works. But anyway, business claims that this is a substantial burden. The government says it's not. But if it's a substantial burden, the government says it's justified by a compelling state interest. What's the compelling state interest? After the Affordable Care Act was passed, the government got a report from the Institute of Medicine, which is a very prestigious, independent, apolitical body, of what were the essential services that should be provided as part of any health insurance plan. And one of them, the Institute of Medicine came back and said one of them is contraception. And the long-lasting, most effective kinds of contraception are actually quite expensive, $1,000 and up a year. So, you know, to a middle-class person, this may not seem like much as part of their health care plan, but it's a disabling amount to somebody who's really watching every penny. And so the Institute of Medicine said, as a public health measure, it would be extremely advantageous to enable anybody who wants to use this kind of contraception to use it. So that's the compelling interest. And then the the narrow tailoring prong of this law, the government says the best way to accomplish this, in fact, the only way to accomplish it, is to rope it into part of an overall employee health plan. So that's the argument, and the government lost this argument in the lower court here. Hobby Lobby won, so it's a government appeal before the Supreme Court. And it's really an extremely important case, even for people that don't care about contraception or the Affordable Care Act or think this is not an issue that affects them in any way. If the court upholds the company's claim, then we get right back to what we were discussing before the break, the Arizona law, or the claim raised by the photographer or the cake baker or the florist that their religion prevents them from adhering to general non-discrimination laws. So what's really the court has to sort out is what's the type of religious claim of conscience, that the country has to honor, has to pay attention to. So, you know, I think it's kind of an open question at the court right now, and I'll be as interested as anybody to see what the court decides.
What happened to the Establishment Clause that we knew and loved and grew up with?
Well, that's a really good question. So, this law, the Religious Freedom Restoration Act, which the Supreme Court has struck down as it applies to the states. The states don't have to abide by it as a matter of federalism, but is upheld as applied to the federal government, purports to address the free exercise prong of the First Amendment. So, you know, the religion clauses of the First Amendment say Congress shall make no law that establishes religion, that's the Establishment Clause, or interferes with the free exercise of religion, that's the Free Exercise Clause. My longstanding belief, and the belief of Justice John Paul Stevens, who unfortunately has retired and is no longer on the court, is that this law actually violates the Establishment Clause by privileging a religious claim over any other kind of claim by somebody who, for whatever reason, doesn't want to abide by a neutral law of general applicability. But that has not gotten anywhere. So there actually is a brief filed in this case, in the Hobby Lobby case, by a scholar of the religion clauses, a woman at Cardozo Law School in New York named Marcy Hamilton, that argues, I think very persuasively, that the Religious Freedom Restoration Act violates the Establishment Clause, but the court has not agreed to decide that issue, and it surely won't decide that issue in this case. It'll simply assume that the law is constitutional and will inquire in this case into whether the law applies to this particular situation.
We need the larger issue decided. You know, is it coming?
Well, I think it will have to. If the court upholds the religious claim here and opens the Pandora's box of everybody saying, you know, my religion prevents me from doing this, that, and the other thing.
And my religion, I can use my religion against somebody who is not in my religion.
Right.
That's the trouble.
Religion as a sword rather than a shield, you might say.
Yes.
I think the court will have to get into it, but they haven't yet.
Yeah. Oh, this is not optimistic. But cheer up. Things may be going better in military justice reform. What say you, Charles III?
George III.
Let's think it's George III. George III. The little-known Charles III's distant uncle. We're in a really interesting place right now about military justice. And I like to mention George III because he was the king in 1774.
Can we put up a picture of George?
Maybe we can. Maybe there's a
there it is.
Picture. Oh, gee.
That's what he looks
magic.
like.
It's magic. So George III, you can see in the background, the fourth person at the table. He was the king in 1774. In fact, just around this time of year, on March 24th, 1774, he signed the British Articles of War, which were the ancestor of what became the Uniform Code of Military Justice, the American Military Justice Code. And the key element of George III's Articles of War from, 240 years ago, was that commanders would make the decision who should get prosecuted for what. Commanders rather than lawyers. And of course, what's happened in the years since 1774 is that the military justice system here and in other countries around the world have increasingly moved to professionalize the administration of justice in the armed forces, so that there are lawyers everywhere. There are lawyers prosecuting, there are lawyers defending, there are lawyers advising commanders, there are lawyers serving as military judges. We have a court of appeals for the armed forces. But despite all the reforms that have occurred over these now centuries, the core element of George III's system has remained with us. It survived one storm after another, and it's right there. And what it means is that even now, in the U.S. system, commanders make the decision who gets prosecuted for what. Now, how has that played out? We've had, just in the last several days, a couple of really headline-making cases, one from the United States Naval Academy at Annapolis, in which a former midshipman was acquitted of charges of rape, allegedly having raped another midshipman at the Naval Academy. The three-star admiral, who was the superintendent of the Naval Academy, sent that case to trial against the advice of the lawyer who conducted a pretrial investigation and against the advice of his own lawyers who were advising him. And the result was a lot of time and effort wasted, expense to the government, embarrassment for all concerned, and an acquittal, which is a terrible thing in a high-profile case. So that's one case, and then probably even more salient in the public eye has been the extraordinary prosecution of an Army Brigadier General, Jeffrey A. Sinclair.
We've heard about him.
We've heard about him. He's probably the best-known Brigadier General in the United States Army right now, not in a good way, who was charged with a variety of improper acts, the gravest of which were forcible sodomy involving a junior officer. And that was a case in which the prosecutor, a very highly regarded Army lieutenant colonel, concluded, based on the pretrial investigation, that the government star witness was likely to be disbelieved because of some flaws, let's say, in her pretrial testimony. Doubts were also expressed by the legal advisor to the commanding general at Fort Bragg. The prosecutor was so uncomfortable about proceeding with the gravest charges in the case that he called his state bar to get a reading on what he ought to do, and he ultimately concluded that he could not in good conscience prosecute the case. And he was removed from the case, or removed himself. It's not quite clear whether it was firing or acquitting. The case proceeded down the road to trial. Serious issues were raised about unlawful command influence being exerted, about whether a lawyer, a government lawyer representing the putative victim in the case, had sort of played the politics card in suggesting the commanding general should kill those charges. And finally, it became apparent, due to some excellent work by the lawyers representing General Sinclair, that the commanding general at Fort Bragg, another three-star officer who should have known better, had basically abdicated his responsibility and determined that if the putative victim wanted to proceed with the serious charges, they would be sent to trial. And to turn over the keys to the car to the putative victim or the complaining witness in a case like this is really not what Congress had in mind when it perpetuated George III's command-centric system. So those cases combined have occurred at a time of heightened attention to military justice because, as all of us also know, this subject has been front and center in Congress with competing pieces of legislation. Congress passed a number of important reforms in December in the National Defense Authorization Act. Senator Kirsten Gillibrand, Democrat of New York, had a bill that would get rid of George III, get him out of this conversation, and move into a 21st century military justice system where commanding officers don't make the charging decision. That bill surprisingly, was filibustered by another Democratic senator, Senator Claire McCaskill, Democrat of Missouri. And even though Senator Gillibrand's bill received 55 votes on the floor to break the filibuster under the bizarre and indefensible rules of the United States Senate, the world's greatest deliberative body, that was not enough. You need 60 votes. And so even though 55 is much more than 50, or that's a majority where I studied mathematics, that bill has died and perhaps will come back to life again. In fact, I'm quite sure it will, in part at least, because of the developments in the Sinclair case and the case out of the Naval Academy.
But there's resistance to this kind of reform. Where is it coming from?
The resistance is coming from the chiefs, the service chiefs, the Joint Chiefs of Staff, and their friends on Capitol Hill. And I'm talking about people like Senator Lindsey Graham, who's very proud of the fact that he actually was a judge advocate and has been a reserve officer. And the Pentagon cast a very long shadow in Congress. And the question is whether they're basically beating a dead horse here or defending an indefensible position. What I should mention is that the United States would not be breaking new ground if it got the commanders out of the driver's seat. And in point of fact, George III's own country, the UK, got rid of the commanding officer's power to decide who gets prosecuted for what some years ago. The same thing goes for Ireland, Canada, New Zealand, Australia, South Africa, even Israel. Israel has had an independent prosecution system in their military justice system since 1955. And obviously that has not impacted adversely on Israel's military might. It's the, as these things go, the superpower in the Middle East right now. So what we're seeing is, what I would say, Jay, is a kind of culture war about military justice. The admirals and generals believe the sky will fall, that national defense will suffer, and that life as we know it will end, basically, if admirals and generals can't make these decisions. And I think experience, including the experience in these recent cases, demonstrates that precisely the opposite is the case. If people have confidence in the administration of justice, if victims believe that they're going to be faced with a fair hearing where the commanding officer won't be able to play favorites, for example, or won't have a horse in the race because it's not so good for commanding officers if there's a lot of criminality going on, so that's a reason to brush things under the rug. If victims feel that they're going to be listened to by lawyers, prosecutors outside the chain of command who will make independent, legally based decisions, then victims are that much more likely, maybe only around the edges, but still that much more likely to come forward with their allegations. And then we'll have a chance of getting on top of the really surprisingly high numbers of sexual assault that have plagued the armed forces in the last few years.
What strikes me is that other countries have reformed where we have not, that we're behind other countries in the reformation of military justice. And maybe we're behind other countries with regard to the issues you've been talking about too, Linda. So, and that would take us to a discussion of Guantanamo, wouldn't it? So we'll take one short break now. We'll come back and then we'll talk about, you know, the jewel in the crown of your trip here. The issue you talked about, the whole scenario you talked about at the law school on Wednesday night. That is Guantanamo. We'll be right back. Castle & Cooke, Hawaii. Investing in Hawaii, creating communities, and providing for the needs of our state. Collateral Analytics, empowering the real estate industry to make better informed property investment decisions. The Foreign Trade Zone, bringing the benefits of the Foreign Trade Zone programs to Hawaii businesses and entrepreneurs. Galen Ho, a senior executive of BAE Systems, a global defense, security, and aerospace company. Hawaiian Electric Company, and its affiliates Maui Electric and Hawaii Electric Light Company on Hawaii Island. The Hawaii Energy Policy Forum, incorporating diverse perspectives to design a flexible and forward-looking energy strategy. Hawaii Energy, the state's energy and efficiency program created to help Hawaii's residents and businesses adopt a clean energy lifestyle. Hawaii Gas, helping Hawaii achieve its transition to clean energy and a better energy future. Hawaii Pacific Health, bringing technology and teamwork together to transform healthcare in Hawaii. The High Tech Development Corporation, attached to DBED, is the state's leading technology agency. The Scheidler Family Foundation, supporting educational, cultural, and charitable organizations, including Think Tech. Okay, we're back, we're live, we're Think Tech Talks. We're talking about life in the law. That's our series today. And the specific episode is the United States Supreme Court next week, because it's all happening now. My brother Jay Fidell on the left side, and my sister-in-law Linda Greenhouse between us, and they are both teaching at Yale Law School and legal scholars on the issues we've been discussing. So we've talked about a couple of things that seem to point to Guantanamo. I'm not sure why. Maybe you guys can address that. But Guantanamo, no, you gave a talk which I really enjoyed on Wednesday night about Guantanamo. We have 10 minutes to capsulize that. Why don't you begin, Linda?
Okay, so as Jean finished by talking about sort of where our military justice system stands in the world. And the world has had its eyes on the situation at Guantanamo Bay since early 2002, when the Bush administration started bringing to the U.S. naval base there in Cuba the people we were capturing from the battlefield in Afghanistan. So the Bush administration's view was they were creating essentially what was going to be a legal black hole. That is to say, there were Supreme Court precedents, and here's how we can meld our two presentations, the Supreme Court and the military. There were Supreme Court precedents that a fair reading would indicate that the jurisdiction of the federal courts would not extend to this U.S. base in a foreign country, so that the Bush administration could do whatever it was going to do there, and it wasn't going to have to be held accountable by two federal judges or by federal judges. That proved to be wrong. So the Supreme Court issued a series of decisions beginning in 2004 that said, by the way, federal judges do have jurisdiction over what goes on there, because the base, although it's within the territory of Cuba, is functionally part of the United States. We hold it under a more than 100-year-old lease that is perpetual until we choose to abrogate it. So it's basically an extension of U.S. territory. And these detainees, the court said in a series of decisions, have the right to petition for a writ of habeas corpus. That's an old English way of, an English common law way of saying, I'm being held unjustly. I'm being held in violation of the law, the Constitution, international law, something. Enable me to get into the court. And the Supreme Court said yes. Now, it hasn't said much more than that. It hasn't said, here are the rights that they have. The Supreme Court itself has upheld orders of release in only a mere handful of cases. Most of the individuals who have ever been held at Guantanamo Bay, and at the high point there were about over 700, and now there's about 150, have in fact been released, repatriated, and so on. We're now stuck with a kind of a hardcore group that we actually don't know what to do with, but those have been essentially political judgments made within the very general framework that the Supreme Court set. Maybe Gene would like to elaborate on that.
It may be helpful if I talk about some of the crossroads that government policy has had to confront. One crossroad we've already mentioned, Linda mentioned, there was a decision what to do with the people that we were picking up in Afghanistan. So do we keep them there? Do we take them to the mainland here, as we did in World War II, where we had thousands and thousands of Japanese and Italian POWs in the United States, farming and doing stuff? It's a little-known chapter in our history. Or do we try to stash them at Guantanamo Bay, presumably beyond the reach of the federal courts? And the Bush administration jumped the wrong way on that. What kind of rights do we give people that we pick up? Do we give them the kind of screening hearing, a little mini hearing that we give to prisoners of war, classic prisoners of war? or do we make up some very superficial, even more superficial type of hearing? Well, the Bush administration decided they weren't going to treat the detainees as prisoners of war and give them the various rights that the Geneva Convention on the Treatment of Prisoners of War from 1949 confers. So that was another crossroads. There was a fork in the road in terms of what to do about punishing those of the detainees who we thought were not only soldiers on the other side, sort of soldiers on the other side, but had actually committed war crimes. And I'm talking here about the people who perpetrated the 9/11 attacks, and also the people who bombed the USS Cole off Yemen. So what were the government's options? The government had an option of trying to prosecute these people in the United States District Court. It decided not to do that, even though the Justice Department has prosecuted many, many, many people on terrorism charges and gotten convictions in case after case after case, including some very draconian sentences.
It's prosecuting somebody right now. Osama bin Laden's son-in-law is being prosecuted in the Federal District Court in Manhattan.
Right. So there was a crossroads. Do we prosecute them the old-fashioned way in federal court, which is the jewel in the crown of the American legal system, or do we dust off this antique? I should have a picture as a backdrop of some general from the Mexican War as the
Winfield Scott.
Winfield Scott, who was the inventor, really, of the military commission. This is a museum piece that was used in the Mexican War because we didn't have a system of rules that covered criminal conduct while we were invading Mexico. It was used against the Indians during the Indian Wars of the middle and late 19th century, including the largest mass execution in American history. It was used in the context of the Civil War, controversially, including a case in which the U.S. Supreme Court held that you couldn't use a military commission to prosecute somebody who was never a member of the opposing armed forces. And then finally, it's a formula or a format that was used in the case of some German saboteurs who tried to invade the United States and create havoc early in World War II. And a military commission was conducted in a conference room, actually, in the Department of Justice building, resulting in Supreme Court litigation, the upholding of a number of death sentences, under conditions that most people today, most legal scholars today, consider basically scandalous. So that was yet another fork in the road, and it was a fork that I think increasingly with the passage of time shows to have been followed in the wrong way. And how in the wrong way? What has happened is the perpetrators of what are certainly very, very grave offenses in which many people who were utterly innocent lost their lives on 9/11. The perpetrators who should have been tried in a matter of months, let's say, maybe a year or two, have thus far evaded justice. We have never gotten to completion of one of the serious military commission cases. There have been a few around the edges. There was an Australian named David Hicks who reached the plea bargain. There was a case of a young Canadian man who was prosecuted. But the main event, the so-called high-value detainees, the people who did 9/11, they're still cooling their heels, so to speak, at Guantanamo. And we're watching as this process sort of limps along to, I'm sure, what must be deep frustration on the part of the families of the people who lost their lives on 9/11. So these have been catastrophically wrong choices time and again by the federal government. In addition to that, Jay, we've seen, and here I have to talk about Congress a little bit. So much of that was about the executive branch. But if you look at what Congress has done, Congress has engaged in a variety of forms of funny business. They've made it extraordinarily difficult for President Obama really to get rid of people who are at Guantanamo for no good reason, to bring people from Guantanamo to the mainland for trial, to use a spare prison to house them in Illinois. One thing after another, the Congress has created roadblocks and has tied the president's hands. And unfortunately, he hasn't expended his political capital in the way I believe he might have to fend off that kind of overreaching by Congress. But he's the commander-in-chief, for Pete's sake, and to have his hands tied is extremely unfortunate. So that's a real problem. And then, not to get too much into the weeds, but Congress also engaged in some funny business when it attempted to strip the federal courts of habeas corpus jurisdiction so that some of these detainees could test the fact of their confinement in the U.S. District Court in Washington, D.C. And Congress was doing a variety of things to frustrate the interests of justice. That's not to say that these people are all angels or anything like that, but it's a distortion of our system, and it bespeaks a surprising lack of confidence in our legal system to try to zero out the authority of the federal courts to at least hear what these people have to say. They won't get very far anyway, as history has shown. But for Congress to say, no, we're going to strip your court of jurisdiction, Judge, because we don't want these people even getting close to getting a hearing, that I thought was reprehensible. And that's another choice, but that was one made by Congress, all on its own.
This failure of the commission system, for sure. It's a failure of the architecture that the Bush administration set in place. But what is going to happen to it now? You know, there's, 150 left there. There are no new inmates coming. Will we just watch this go on and on and on until they all die at Guantanamo? What have we set up here? What kind of monstrosity will this be going forward?
Well, it's very unclear the extent to which we're going to be able to keep claiming authority to hold them at all, because they're being held under the authorization for the use of military force, which is a statute that Congress passed urgently in the immediate aftermath of 9/11, and that the Supreme Court has interpreted as giving the underlying authority for these detentions. So, of the 150 or so, the majority of those are people who've been identified as not presenting a current threat and who can be repatriated, and that's happening slowly. There's a core of about 40 who don't fall into that category, who are being reviewed under a process. The administration has hired somebody new, a Washington lawyer named Clifford Sloan, who apparently has been quite effective in managing the case-by-case review process for these remaining 40, and a couple have been sent back, a couple have been found ineligible to be sent back, but they'll be reviewed again in 6 months. So it's in a course of attrition that's really painful to watch, and is the aftermath of the cascade of errors made along the way that landed on the president's plate, and he's trying to carry out the promise he made in one of his very first speeches after he was inaugurated in January of 2009 to close Guantanamo.
So, it suggests that, we have a whole bunch of bad precedent that came out of this, which hasn't been cleaned up, which hasn't been reversed. I mean, we kind of messed up the law in this area. What's going to happen with the next Afghanistan?
Well, I think the concern that we might leave a loaded gun lying around, a judicial loaded gun lying around, is a real one. But actually, if you look at what the courts have done, the Supreme Court has, in fact, maybe not as quickly as we would like, maybe not with the clarity of voice as we would like, but the Supreme Court has been a defender of the rule of law at Guantanamo. They've said, and they've struggled to do this, but they've said, look, we're not going to permit the executive branch to treat Guantanamo as a law-free zone. We're going to fight like crazy when Congress tries to zero out the habeas corpus jurisdiction of the federal district courts. We're going to give people some kind of rights who want to, if people want to contest their their detention. We're going to impose some kind of reasonable rules of fair play in military commissions. So it's not entirely a negative story. I think, you know, you could quarrel with the justices' unwillingness at times to take cases that you sort of would have thought they'd have taken, or taking them a little earlier rather than a little later. But there are also moments of heroism. And I think Linda mentioned before Justice John Paul Stevens. I think he will prove to be one of the heroes of this era, an era that could use some more heroes, in my opinion. But he definitely be one, because he performed an extremely noble role, and one that's in keeping with the highest tradition of the Supreme Court.
So since Bush, you know, when we always wondered, you know, whether he was on the right track or going south on things, you know, it seems to me that we've lost some of the better process we had before. And that's, to me, the common denominator of all the subjects we've been talking about. And I wonder if you could comment on whether there's a connection along lines like that of all these subjects. I mean, what's the state, what's the condition of American constitutional law, of the rule of law, of the, you know, the First Amendment, of reform, of things that should be reformed? Where are we these days? You know, if we went wrong during the Bush administration, we went off course, how do you, if that's true, how do you get back on course? Or is that just part of the travels, and you never actually get back to where you wanted to go in the first place?
Well, you know, these are huge generalizations, Jay Fidell.
I'm just provoking you, Linda.
Yeah, so, you know, there are pendulum swings, and there have been throughout the course of American history. So, you know, we're off the track in a couple of areas. I don't think we're fundamentally off the track in every area. You know, one of them I would say is the voting rights decision that the court handed down last June, the Shelby County case, which the court invalidated the core part of the Voting Rights Act of 1965. That was an outrageous decision. And we'll see how the political system responds. You know, I think my view is there's a constant dialectic between the Supreme Court and the political branches and the polity as a whole, and it doesn't play out you know, on a month-by-month basis, or necessarily even a decade-by-decade basis. But as I've written and said over the years, we end up with the Supreme Court we deserve. So it either reflects well on us or badly on us, but it reflects us ultimately. It reflects our choices and our political choices, choices of who we choose to be president, who's going to nominate people to fill the vacancies, and so on. And if the country decides it doesn't like the way things are going, we can change our political horse. And that's been really the story throughout American history.
Jay, my reaction is this: that there was a book written years ago with this title, "A Machine That Would Go of Itself," or would go of its own. Michael Kammen's book, and it was about the framing of the Constitution and the basic structure of the Constitution. And the title doesn't, of course, do justice to you know, everything that Professor Kammen had to say, but the notion was, once it runs, and you could sort of let it unfold. And the answer is, my reaction to that, thinking about it today in light of your question and Linda's comments, is that it may run of itself, but it requires constant attention. And the notion that we can sort of sit by, not to worry, that generator is going to keep going, it'll be fine, is an illusion. And in fact, it requires constant attention, constant vigilance, if you will, and constant activity on the part of people who are concerned about the state of our democracy.
Thank you, Gene. Gene Fidell, my brother, and my sister-in-law, Linda Greenhouse, both teaching at Yale Law School, talking about life in the law and the U.S. Supreme Court next week, which is, you know, maybe next few weeks. Thank you so much for joining us today.
Thanks for having us.
Aloha.